Started. Kirkpatrick Price is a licensed CPA firm and PCI QSA, providing assurance services to clients worldwide. Our firm has over 13 years of experience in information assurance by performing assessments, audits, and tests that strengthen information security and compliance controls. We offer both regulatory compliance and information security services. We provide consulting services such as policy and procedure drafting, risk assessment, internal audit plan and development, and readiness audits. We also provide guidance and audit services on frameworks such as SOC 1, 2, and 3, PCI, HIPAA, HITRUST, FISMA, ISO 27001 and 27002, and now GDPR. We also encourage you to connect with us by subscribing to our blog, visiting our library of recorded webinars so you can catch up on any series at any time, and following us on LinkedIn, Twitter, and Facebook. We are very lucky to have Mark Heinley as our speaker for today, and I want to give Mark as much time as possible. So Mark, I'll hand it over to you.
Thank you, Jenna. My background is as an attorney with the Florida Bar, including public and private practice, experience in regulatory affairs, and internal regulatory compliance. And I'm SAM certified in the law of data security and investigations. And I appreciate, like Jenna, your attendance at today's webinar. I want to give you the purpose of our webinar today. I know that what the world, before I do that, let me give that legal disclaimer that Jenna briefly showed up on the screen. This presentation is not for legal advice. If you do need legal advice, please contact an attorney, and your participation in this webinar does not establish an attorney-client relationship with us. But we welcome your participation, and we're happy to share our experience and advice with you. So our presentation is jokingly called Everything You Wanted and Didn't Want to Know About GDPR. As Jenna mentioned, there is a large amount of GDPR content, and it's growing seemingly by the minute. But we think we're uniquely positioned to provide you with a combination of regulatory compliance experience, legal background, and then information security and auditing experience. And combining all of those perspectives together is the reason we think this presentation and future presentations, along with our services, will be useful and helpful to you. So let me give you our agenda for today's presentation. We're going to do a quick summary of GDPR. Then we're going to do a comparison to U.S. law, since most of our audience is based in the U.S. We're going to talk about roles, requirements, give some industry-specific content, and then we'll provide some practical implications before we wrap up and go into question time. So let's talk about a brief summary of GDPR. For the purposes of this webinar, we're assuming that GDPR applies because our goal is to understand the requirements within the law and then talk about implementation. So you might want to ask, why we would need to give a brief explanation of the law if we're already going to assume that the law applies. And the answer is that we're hearing from multiple companies, both existing clients and potential clients, and at industry activities where they say, we're being asked about our GDPR compliance, so we need to do something, but we don't know what we need to do, and we don't know what they're asking about. So we've got organizations that already believe they are potentially subject to GDPR, either because they've decided that on their own or because their clients are asking for it, but they're not sure where to begin. So let's talk quickly about GDPR as a law, and then we'll move into the comparison section. So GDPR is a European law governing the processing of personal data of EU data subjects wherever the data is held, which means that it has potentially global jurisdiction. The applicability of the law follows the data rather than following the person and their location. It also grants rights to data subjects, and we'll talk about those in a little bit. And then it creates obligations for protecting data and for facilitating data subjects' rights. And then finally, it establishes enforcement authority for monitoring compliance with the law and then implementing penalties, which are incredibly significant, up to 20 million euros for violations of GDPR. And organizations have said, just to give you a sense of how important GDPR is as a data protection law, instead of it just being one of many other frameworks or requirements, according to Risk and Insurance issue from June of 2017, PricewaterhouseCoopers conducted a survey which said that 92% of companies said GDPR was their top compliance priority, and 75% of those companies said that they would spend at least $1 million working towards GDPR compliance. So this is one of the most significant data protection laws in the recent history, and it is potentially global, and the implications of it and the cost to get ready for it and the cost for not complying with it are significant. So that gives you a little bit of background about the law. Let's talk quickly about a comparison to U.S. law, since most of our audience is based in the U.S. There are some similarities to existing U.S. laws. For example, HIPAA and the Fair Credit Reporting Act have elements where you're only allowed to disclose the minimum data necessary to accomplish the purpose of the disclosure. There are rights which are similar to GDPR rights, including the right to access, the right to amend data, the right to restrict data, and the right to portability. And then there are also similarities to Graham-Leach-Bliley, also referred to as GLBA, requirement to respect privacy and to protect data security. But there are also some significant differences. First, GDPR is much broader in scope than any of the three laws that I referenced because it applies to any kind of data. It's not just healthcare data. It's not just financial data. It is any personal data relating to a data subject. So it can apply to any, impact any industry. There are more rights than most U.S. laws, and those rights are more substantial than the rights generally attributed in U.S. law. There's also the opt-in versus opt-out difference between GDPR versus some U.S. laws. You know, if you're familiar with online transactions where you're signing up for a username, password, or a profile, and they've got a couple of options to receive notifications about deals and marketing, and those boxes are sometimes automatically checked. And if you're not interested in those, then you have to uncheck the box. GDPR requires organizations to establish an opt-in provision where those boxes remain unchecked as a default. And then the sanctions that I mentioned are more severe. So you could have millions of dollars and millions of euros of penalties. So that just gives us a context of how GDPR compares to some U.S. laws that you may be familiar with that relate to data protection. Now that we've made that comparison, let's talk a little bit about roles, because this is where we're going to understand, this is going to set the groundwork for requirements, because GDPR requirements depend on the role in which you fulfill under the law. And there are essentially 4 primary roles for the purposes of compliance, but then we're going to talk about 2 more after we go through these roles. And these are controller, joint controller, processor, and both controller and processor. A controller is defined as a natural or legal person, public authority, agency, or other body which, alone or jointly with others, determines the purposes and means of processing the personal data. So we need to be careful when we're trying to understand our role under the law about defining whether we are a controller based on the activities that the entity performs. Being a controller doesn't necessarily require the direct collection of data from the data subjects. More importantly, to determine whether you are a controller is asking and answering the question, how much authority over the data does the organization have? The greater the authority the organization has over the data, the greater decision-making ability, the more likely it is that an organization is a controller. Then there is a joint controller, which means that you could have multiple organizations having authority over data. And so if you had a couple of different organizations in an agreement to collect, use, combine, and then disseminate data, you might have a controller and processor relationship, or you might have a joint controller relationship. For the joint controller relationship, it's when the purposes and means of processing the data are jointly determined, and the requirement is to clearly define the roles and the responsibilities. And there may be a challenge when deciding whether or not you have a joint controller relationship, because there is a difference between sharing a data pool and sharing authority over that data. Simply sharing a set of data does not necessarily establish a joint controller relationship. It could be two separate controllers, or it could be a controller and a processor, but if there is mutual authority, then you likely have a joint controller relationship. Then you have what is called a processor, which is a natural or legal person, a public authority or agency, which processes personal data on behalf of the controller. So think of this in terms of service organizations, which you may be or which you may oversee and use, that act at the direction of another organization and are not able to or not authorized to conduct processing that's under consideration without the work and authority of another organization. Now, the more authority a controller gives to a processor, the more potential there is for that processor to become a joint controller. So let's go through a couple of examples, and then we'll show a visual in a minute of what this might look like. For example, a controller might be a manufacturer of or retailer of shoes, selling those shoes to EU data subjects. And when they sell those shoes, they might have a form as the individual goes to check out and purchase those shoes to enter their name and their email address, their physical address. It could include other pieces of personal data about the subject, and the shoe manufacturer or retailer then has the decision about what to do with that data. A processor would be, for example, a marketing company distributing marketing material on behalf of that shoe manufacturer or retailer. And the processor might have the authority to decide what color or font or image or marketing channels they use, but they wouldn't necessarily have authority about what data to use and who to market that data to. A joint controller example might be a staffing company and their clients, so a firm that is looking to bring in talent to other organizations. The staffing company might have authority, partial authority over that data, but the client might also have authority over that personal data. And the more it's important in that situation to clearly define the roles and the responsibilities of that staffing organization and the client to determine what should be done with the data. And then you might have a situation where an organization is both a controller and a processor at the same time. For example, you might have a software as a service provider serving as a processor based on the data they receive from their clients, but they also might serve as a controller based on the fact that they are an employer that has European employees. And so they have two different sets of data, and those two different sets of data they have different authority and responsibility to. One makes them a processor and one makes them a controller. Another example might be a data center that serves as a processor for the data that it receives from clients and stores, but it might serve as a controller for data that it gathers in its client support functions that's completely separate from the data that it receives from its clients as its core function, but it might receive data about a client's employees that it could use for marketing purposes or other decision-making purposes and have authority over. So let's take a look at the next slide to give you a visual breakdown of some of the different roles and the way that they connect to each other. So at the top you see GDPR and the overarching law, and then underneath you see some of the different potential options that you have and the roles that you have. You could be a controller with processors working underneath and in connection with each other. You could have joint controllers that have mutual responsibilities under the law, both with authority but not with total authority. And then you could have an organization that is both a controller and a processor. And if that seems confusing, maybe our next slide will give you a visual representation of what it ultimately might look like. And this is a chance for my 4-year-old son to provide some content for our presentation today. Ultimately, I do think this is going to be one of the greatest challenges under the law is understanding your role, because the responsibilities flow out of the roles that you have, and because there is a potential to serve in multiple roles and multiple variations and then connect to other organizations that are also processing data of EU data subjects, that we might feel at times like our brains and our organizational charts and our data flows look something like this. All right, let's talk about the last two roles that are defined under the law, and those are the roles of data protection officer and supervisory authority. The data protection officer is an individual that has to have the required qualifications and independence to serve within an organization. They must have expert knowledge of data protection law. They must be independent from an organizational reporting perspective. They can't be told how to do their job. They can't be penalized for doing their job. They can be a person within an organization that's also fulfilling other roles, as long as those other roles don't create a conflict of interest. And they can also be an internal employee or an outside contractor. And then finally, the law, GDPR, talks about supervisory authorities, and those are the independent public authorities for each EU member state that are responsible for monitoring the application of GDPR and addressing noncompliance. These are the government organizations that you will be interacting with, and those organizations have the authority to create additional guidance regarding GDPR compliance. So now that we've talked about some of the roles, let's talk about some of the requirements. And first, we're going to do the requirements for controllers, and then we'll talk about requirements for processors, and then we'll talk about requirements that are jointly apply to both controllers and processors. First, controllers must demonstrate compliance with the principles identified within the law. Because today's session is only an hour, we don't have time to go into detail related to all these principles and some of the requirements, but we're going to give you an overview and just give you a sense of where these principles apply for those organizations that are still learning about GDPR. For those of you who are much more familiar and know this information thoroughly, hang in there. I think some of the industry-specific content will be of use to you. So there are 6 different principles under GDPR that controllers are required to demonstrate compliance with. They are lawfulness, fairness and transparency, data minimization, accuracy, storage limitations, and integrity and confidentiality. And so we're talking about demonstrable compliance. We're talking about things like internal monitoring and reporting, internal auditing and reporting, and external auditing and reporting, among other things. But all of these elements, there must be a sense of demonstrable compliance. Another requirement for controllers is to facilitate data subject rights. And there are the same number of rights as there are principles. There are 6 rights: the right to access, the right to rectification, the right to erasure, the right to restriction of processing, the right to portability, and the right to object. I want to talk briefly about these rights because they will give you a sense of where your organization is going to have some implementation considerations. The right to access, as I mentioned at the beginning, is similar to the right to access under existing U.S. law. It includes the right to obtain information from a controller about the data being processed by that controller, along with other specific pieces of information. This is not a large change from previous EU data protection directives, but it could be a significant change to U.S. companies who frequently create lengthy and complicated and hard to obtain disclosures and notices about the kind of data they process and who else has that data. So the right to access is really about the right to information about who is processing, what they are processing, and the purposes for which they're processing personal data. The right to rectification is the right to have controllers delete or amend inaccurate or incomplete data. HIPAA already has a right to amendment, but it does not have a right to deletion, and it is not as broad and extensive as the right underneath GDPR. And this is a challenging requirement to be able to track data and then find it and then fix it within certain limitations. The third right is the right to erasure, which is not just to change or delete inaccurate data, but the right to delete all personal data. And in certain situations, there are times when a controller is permitted under the law to maintain data, even when a data subject has asked for it to be deleted, when that data is necessary for the purposes for which the data was obtained in the first place, or whether there's legitimate grounds for maintaining the data, or there could certainly be considerations if there are U.S. laws that are requiring data retention in certain circumstances. That could serve as both creating a necessity and a legitimate ground for continuing to process that data. So this is going to be a challenge for organizations in terms of their data retention schedules to ensure that they are both facilitating the right of data subjects while also trying to comply with U.S. law or other international laws and their own internal data retention policies. The fourth data right is the right to restrict processing. The article that gives this right doesn't specify the nature of the right, but there is a recital in the law that gives 3 types of restrictions. So one example is temporarily moving data to another processing system. The second example is making the data unavailable to users. And the third example is temporarily removing published data from a website. This could also be considered, this isn't in GDPR, but another instance could be restrictions on sharing data with other entities, whether they are affiliated with a controller or processor or not. The fifth right is a right to portability. And this is more, the right to access, the first right we talked about is about access to processing information. The right to data portability is what we may typically think is the right to access, which is the right to actually receive the data yourself or to have that data sent from one controller to another controller. There is a good resource, the Article 29 Working Party, which is an organization that is providing, a part of the EU that is providing additional guidance regarding GDPR, has some guidelines on the right to data portability. If you're looking for additional information, then stay tuned for our further content for more information about specifics of GDPR. And then finally, there is the right to object to processing, automated decision-making, and profiling. So this is a request that rather than a controller ceasing any kind of processing, completely eliminating the data, as in the right to erasure, this is about objecting to different levels of processing. So you could object to processing based on the lack of a public interest or legitimate interest on the controller. You could object to profiling, which is an automated process of personal data to evaluate different aspects of a person, such as their work, their economic situation, their health, preferences, interests, behavior, location. Profiling also includes, for example, if you were looking at who works in a certain industry, how much money they make, where do they live, and what kind of goods and services do they like, and that process was automated, data subjects have a right to object to that kind of processing. And then the third area of objection is the right to object to automated decision-making. So this is something that could involve profiling, but it may not. It's decision-making without human involvement. So for example, if there was a decision to offer a mortgage that was based solely on an algorithm and there was no human who reviewed a credit score or offered any input on the decision to extend the mortgage to the data subject, then that would be an automated decision-making for which data subjects have the right to object to. So controllers have to, in the course of the work that they do, not only protect data, but they also have to ensure that data rights have, their data rights are facilitated. This is a list in front of you of some additional controls that we're going to go through fairly quickly. Controllers are required to use appropriate technical and organizational controls to protect data. Those controls can include human, technological, process controls, and expertise. They also have to conduct what's called a data protection impact assessment. That is a process that is similar to a risk assessment, but this is something that is done whenever a controller engages in new technology or processing new data or special kinds of data. And so this is an ongoing requirement. And GDPR gives some required content for data protection impact assessments, but it doesn't exactly establish the process by which organizations have to do what's called a DPIA. Now, some of the supervisory authorities have given some guidance on how to conduct a DPIA, and we'll be talking more about those in the future as well. But this is something organizations are going to have to establish defined procedures for doing, not only the process for completing one, but decision-making for when a DPIA must be completed. Controllers also have to ensure a proper legal basis for processing. This gets back to the principle of lawfulness that we just referenced at the beginning, which means you have to have a legal ground for having or using the data of which you have. And there are a couple of different legal grounds that you could have. You could have the consent of the data subject. It could be the performance of a contract. It could be a legal obligation to protect vital interest of the data subject. It could be public interest. It could be necessary for the legitimate interest of the controller. So there are multiple different ways that a controller could have a valid legal basis for processing. It is important for organizations to understand the ways in which they obtain data so that they can ensure that they have a legal basis for each of those different means. In case your organization obtains data and processes it based on different legal means. So in one case, an organization might process data legally based on the consent of the data subject, but in another way, the organization might process the data based on a contract. And there are different implications under the law depending on which legal basis you're using for processing. In addition to having a legal basis for processing data, you have to have a valid transfer mechanism for international transfers. So controllers both in the EU and outside of the EU have to ensure that one of the several different valid transfer mechanisms exist. So in some cases, the EU might say that another country's laws, data protection laws, are sufficient, and it's what's called an adequacy decision. Another situation might be a binding corporate rule is a valid transfer. Those are documents that must be submitted to supervisory authorities and approved by the supervisory authorities before they can stand as a valid transfer mechanism. And then there are standard contract clauses and standard clauses that organizations can use to ensure a valid transfer mechanism. For organizations in the United States, this is where Privacy Shield comes into play, which is something created by the FTC and is a voluntary self-certifying attestation that you comply with certain principles, and it has the effect of law once you voluntarily go into it. But the EU has said that United States data protection laws are not sufficient. So the way that they have given essentially what is considered an adequacy decision to the United States is if organizations are compliant and certified under Privacy Shield. So the last three rights on our screen are a requirement for controllers to monitor their processors. They have to ensure that the only processors they're using are the processors that can provide sufficient guarantees of data processing and protection of rights. They also have to ensure that they have breach notification processes in place. And while every organization that is of any worth has breach notification policies and procedures, the requirements under GDPR are generating a lot of interest and consternation because the documented requirement within the law is a 72-hour deadline to report. Now, there are some exceptions to that 72-hour deadline, but the fact that it exists in the first place, even with exceptions, is enough to give organizations significant cause to be able to turn around and report something like a breach to a supervisory authority within 72 hours. There are also requirements to notify data subjects individually of breaches. And then the final requirement on this slide is to maintain a record of data processing. GDPR specifically spells out the elements that are required in the record keeping, and we won't go through each of those, but that is something that organizations are going to have to maintain. Now that we've talked about the requirements for controllers, let's talk a little bit about the requirements for processors. Whereas controllers are required to ensure that the processors are performing according to GDPR, the processors have to provide sufficient guarantees of their own appropriate technical and organizational measures to protect data subjects' personal data. And that is going to be something that is going to require ongoing vigilance and awareness of industry standards and future guidance that's put out by the EU or supervisory authorities, because GDPR just doesn't say, here are the standards in place to ensure that if you have these in place, then these are the appropriate technical and organizational measures. And it's somewhat understandable. As technology changes, as threats change, which are part of the reasons that GDPR was created in the first place, the measures that are considered appropriate are going to change as well. So there are different standards that organizations might consider using, industry standards, and hopefully there are industry standards that come out as a result of GDPR. The law specifically encourages the creations of certification and standards to help organizations know whether they're compliant or not, but as of this moment, there really aren't those kinds of guidelines. So processors have to have their own appropriate controls in place. They also have to support controllers when they undergo a data protection impact assessment. When the controller is working through that process, it's likely that they'll be using a processor for part of their activities, and so processors are required to participate when controllers are undergoing a DPIA. Processors also have their own notification requirements. Those are breaches, just like the controllers. And then there are also requirements regarding the use of what we could call a sub-processor. So if a processor is going to use another organization to help it fulfill its responsibilities for a controller, they have to give prior written notice to the controller and obtain written permission from the controller before engaging another entity to perform services. And that includes both using a processor and then using a sub-processor and changing a sub-processor. Processors also are only allowed to process data as they're authorized by the controller. So they have to ensure that they understand very clearly what their obligations and authority is from the controller, and then ensure that their processes are compliant with those expectations. And then finally, there are certain circumstances in which processors have to maintain the same kind of processing records that the controllers are using. And if we say processing one more time, we might win $1 million. But those requirements are when a processor has 250 or more employees, when they process data that is likely to result in risk to the rights and freedoms of data subjects, when they process data more than occasionally, when they process special categories of data, and when they process data related to criminal convictions. So that requirement, that final requirement, is a conditional requirement. Now let's talk a little bit about the requirements that are apply to both controllers and processors. One of those is to appoint a representative in the EU and this applies to controllers and processors that are not located in the EU. Now, there are some exceptions to this appointed representative requirement. That's when a processing is either occasional or it doesn't include large-scale processing of special categories of personal data, and it's unlikely to result in the risk to the rights and freedoms of natural persons. But those terms are very loosely defined outside of special categories. What constitutes occasional processing is undefined. What constitutes large-scale processing is undefined. What is unlikely to result in risks to rights and freedoms is undefined. So if organizations were to decide to take the conservative route, they would go ahead and appoint a representative, and they would, considerations might be what member state in the EU you process most of your data from, what kind of data do you process, and some other things that would allow you to decide where it's best to locate a representative. And then the other requirement for both controllers and processes in certain circumstances is to appoint a data protection officer. We talked about the responsibilities and requirements for qualifications for data protection officers, but this is now on the controller and processor. If an organization's core activities require regular and systematic processing on a large scale, examples include insurance or search engines for advertising or real-time location data for like an international fast food company, those have been recommended and proposed as large-scale processing. Or if core activities include processing large scales of special categories. And I don't think I've defined it earlier, but special categories of data include race, ethnicity, political, religious, philosophical beliefs, trade union membership, sexual activity, and health. So if there was large-scale processing of any of those special categories, there would be a requirement to appoint a data protection officer. And again, the Article 29 Working Party has issued guidance on data protection officers, and we'll be talking more about them in the future as well. All right, let's get to some industry-specific information so that we can really put some, give some guidance that's specific that might be of interest to you based on your organization. So first, let's talk about information technology support. So many organizations who serve as SaaS companies or other information technology or information security support are going to be serving in the roles as controller and processors. And so some things to consider, review your master subscription agreements to make sure they address GDPR issues like consent, responsibilities of each organization, and data retention, because those are going to be key in determining compliance with GDPR. Also, evaluate your incident response plan. Given the 72-hour window, even with the exception, it's critical to evaluate whether your incident response plan is capable of responding within that time frame when required, and responding in a timely manner if 72 hours, if there's justification for not responding or providing breach notification within 72 hours. Additionally, it's important to identify any international data transfers that your organization participates in, because those are only permitted when there's either an adequacy decision or those the boilerplate standard language or the binding corporate rules, one of those valid transfer mechanisms. So you have to know when you are transferring data outside the EU and to which country and what would be the valid transfer mechanism in that case. And then the final thing to note for information technology support would be ensuring that you have processes that are in place to facilitate data subject rights, like the right to amend data and the right to erase data and the right to object to certain processing. There are organizations who've played an information technology support role for years who have not had to have a role in addressing any of data subject rights and haven't even had to consider whether or not they would have to do anything if certain rights were exercised. And so this is going to be a challenge for those organizations. The second industry we want to talk about, I've titled it financial arrangements because I really couldn't think of a better way to explain this. I don't want this to anyone who's not with a financial services company like a bank or a credit union or the organizations that we think of as typical lenders to not pay attention, because this really applies to, could apply to anybody that's selling a good or service because of some of the considerations related to automated decision-making and profiling. So one of the questions that you're going to have to ask within your organization is, what constitutes credit? Does a monthly payment plan of any kind constitute credit? Because if it does, there might be impacts to your ability to, in a compliant manner, conduct profiling and automated decision-making. And then what other financial arrangements create enough of an effect to trigger additional implications under GDPR? So you have to ask yourself, if you have a subscription service that has monthly payment arrangements and there's any automated processes there, do you have the ability to inject human interaction? Are there any automated decision makings, and what is the significance of those automated decision making? areas within your organization. So these financial arrangements, I think, are really going to cause challenges to organizations because they're not going to think of themselves as financial services companies, but some of the decisions that they make with respect to payment and things that might be considered credit or that might have a significant impact, like the extension of credit, could trigger additional requirements under GDPR. The final category relates to processing data for children. So that's offering goods and services or just to children or just processing data related to children. And particularly, this is a gray area for profiling and automated decision making. The Article 29 Working Party recommends that organizations not conduct profiling or automated decision making on children. And if they do conduct any kind of profiling or automated decision making, they say that you need to have controls that are appropriate for children. So we talked earlier about having appropriate organizational and technical controls, and those are sort of at a high level, but if you're dealing with the data of children, then the controls have to be considered appropriate for another level because, you know, the law says that children are less aware of the risks and consequences and safeguards and rights that they have related to their data. So there's a different level of consideration for whether or not the controls that you have in place are appropriate for processing the data of children. Recital 38 in the law has some specific protections related to marketing and creating personality and user profiles and services that are directly offered to children. So there's some areas that you need to consider regardless of whether your organization's core services relate to reaching out to or targeting children. If you allow children to create personality or user profiles, then you may have some greater risk and obligation under the law. So for this final industry-specific issue, a couple of questions to ask are, to what extent does your organization collect data from EU data subjects that are children? To what extent is that data used for automated processing or profiling? And then what additional controls do you need, if any, to be compliant under GDPR? All right, now we're entering the home stretch. We're going to talk about some practical implications of our discussion and then implementation, and then we'll wrap it up with our conclusion and a few minutes for questions. So the first item, if you're asking yourself or asking virtually through this webinar and nobody's hearing you and you're saying, where do I start? My recommendation is that you would start with data mapping. Thinking about all the points of EU data that you received as personal data, where it comes in, who accesses it, where it goes out, including all entities, jurisdictions, the type of data, the controls that are in place, whether any onward transfers, and then what I call nooks and crannies, areas that are not your organization's core services that might be a place where you receive EU personal data. For example, if your organization somehow has an online message forum, but that's not your core function, you might have some risk there. Customer satisfaction surveys, I've completed those recently for some retail purchases, and it asks for data that would certainly be considered personal data under the law. And that the satisfaction survey was not what the organization that I was interacting with, it's not how they generate their revenue, but they have that, and they're now obtaining my data in 2 different ways or 3 different ways. And so there might be a tendency to overlook those areas because it's not what they do as a business, but that's an area where data mapping is also critical. And then also talent acquisition and HR activities is another area where data mapping might throw some organizations off because they might overlook their own employees' data and retaining and obtaining talent. Second area is to think through your change management. Ask each time when you're talking about change management under GDPR, do you have to conduct a data protection impact assessment? Ask whether or not the change is going to require the use of 1 or more new processors. Is there going to require new consent from data subjects? Is it going to implicate the exercise of rights. So the rights are the same, but if you're using new technology or engaging in a new service, you might have to update the way that you facilitate data subject rights. And so the way to do this, I think, is to create a decision tree model that says if we change technology, if we change services, if we change the kind of data that we're receiving, what are the downstream impacts? It's partly covered by a data protection impact assessment, but it's not completely. And then does our organization have standards in place? Standards would include opinions about the legal implications of the change for addressing each of those downstream impacts. So knowing here's all the downstream impacts, and then how do we think each of those downstream impacts needs to be addressed? Self-reflection. Does your organization have a clear position on its posture under the law? Does it know if it's a controller or a processor or a joint controller? Does it use, if you're a processor, would you use other sub-processors? Also, does your organization conduct profiling? Does it conduct automated decision making that results in a significant legal-like implication? Do you have legal bases for all of your processing, and do you know what those are for each of the methods of data processing that you engage in? And then finally, do you have valid transfer mechanisms for any international data transfers? The fourth item would be ensuring that you have strong internal communication related to things like breaches and the exercise of data subject rights. It's not just that you can facilitate those data subject rights, but it's that you can do so in a timely manner, and you know your organization knows when it has a solid ground to object to the exercise of those rights. And then finally, the fifth item is to monitor regulatory developments. So because the law does not go into effect until May 25th of this year, we don't have any enforcement action to tell us what was compliant or what was non-compliant. We don't have the certifications or the codes that the law anticipates. The only thing that we really have that's good are those Article 29 working party guidelines to go off of. But so it's important to monitor developments as they come out because we're pre-implementation for this law. So to wrap up, for the takeaways for today, to think big. Think big about the scope of data for GDPR, think about the scope of impact, think about the sanctions for noncompliance. Roles and responsibilities. As an organization, do you know what role you are? If you do, then you should have a better sense of the responsibilities that you have under the law. And then also at the individual and business unit level, do you know what responsibilities that you have or each unit has under the law? And then industry-specific issues. In addition to the industries that we talked about today, I have seen and read recently about there's significant content for other industries like healthcare and marketing and retail and many others where associations are putting out content to address things that are particular to those different industries. And then finally, Kirkpatrick Price is here to help with our services, consulting and gap analysis, assessment, and then other compliance services, and then also the future content that we have planned, both webinars and written content. So we want to help you as much as we can, and we thank you for your participation today. We have just a few minutes left, so if there are any questions, you can reach me at this phone number and this email address, and then I think, Jenna, do you have any questions from our audience today?
We do. Some of them are pretty specific, so I'll try not to be too repetitive. Most of these are about a controller versus a processor. So let's start with this. We're a SaaS company that collects usage data about our end users. We also share this data with our customers, and we use it to help drive messaging and drive adoption. Is this a joint controller scenario?
There's several different things I think about when I hear that question. It's difficult to know. We'd be happy to talk through that with you more. It could be a joint controller scenario. It could be a scenario where you just have shared data pool, and so you could be both controllers, but not necessarily joint controllers. It will be important as a throw-in to ensure that you have a proper basis for sharing that data with other organizations and then using that data to drive messaging, those are two different things that you would need proper legal basis for both of those items.
This is another question about a SaaS application. What about a single tenant deployment SaaS application where the customer controls all the data and owns the AWS account collecting the data, but the SaaS vendor provides the software?
So it sounds like all of the, if this is a question about, controller and processor, it sounds like that SaaS software would serve in a processor role. It sounds like they have no decision-making authority over the data, and in that case, they would be a processor.
Okay. From Alan, do you consider a data center in the U.S. who is only providing storage of EU citizens' data but not managing the data a controller, a processor, or nothing?
I think they would be considered a processor based on the information that Alan provided in his question.
Dave would like to clarify, an organization can be both a controller and a processor, but not for the same data. We control employee data, but we process client data, as outlined in general service agreements.
Yeah, in that case, you're talking about being a controller and processor of two different sets of data. There are some interesting discussions about whether or not an entity could be both a controller and a processor for the same set of data. I have heard conflicting reports and conflicting perspectives. For example, some have identified that within an organization, the chief information officer might be a controller, and then different business units within that CIO's organization could serve as processors. The marketing arm of that company could be a processor. They take the data from the CIO, who has the decision-making ability around it, and then they take it and they use it, they disseminate it. I've also heard organizations say, or perspectives that say, it clearly requires different entities to be a controller and a processor. So to me, it's not perfectly clear at this point.
A company that is in the U.S. but has EU citizens on staff, do they need to be GDPR compliant?
I think there's definitely some consideration if the data they have about their employees is typical of what Kirkpatrick Price has about us as employees and what I've experienced as an auditor and as an attorney, that it's likely that there are GDPR compliance considerations.
Okay. Another one, let's say that the company is under a different country or region than a controller. Do we both need to follow the regulations of each region?
So it depends on what they mean by region. So GDPR, as I said, follows the data and not the data subject. If they're talking about supervisory authorities promulgating their own requirements that are different, then there would be application considerations for both of the supervisory authorities. If they're talking about, for example, transfers from the EU to the United States, and you have laws that seem on their surface or are certainly different, that's going to be an interesting situation where you might have a conflict between European law and U.S. law if a processor is in the U.S. and the controller is in the EU. What does an organization do? But I know that the U.S. federal government, as it's tried to do through Privacy Shield, is trying to work with the EU to facilitate compliance here in the United States. But I suspect that there will be some bumps in the road. Some people project the United States should or will look towards implementing something like GDPR to facilitate data transfers across the Atlantic Ocean.
Great. This is another question kind of about employees. How does the right to object impact automated data processing related to the data controller's EU-based employee performance?
Well, the rights are not absolute in all cases, so there can be exceptions to some of those rights. So there's depending on some of the specifics of that question, that might be a good item for us to talk individually about. But those rights, even though they're strong, they're significant, they're not absolute. There are, in most cases, opportunities for an organization to deny the requests made in those rights. So I think that's a really a good question, but it would take consideration of the specific objection and the activity, the HR activity, whether we're talking about a background check or marketing. Those would be different, I think, different considerations for both of those, whether the objection should be facilitated or not.
Awesome. If you have any more questions, you can send those to Mark at that email on the screen, or give him a call, or you have my email in your inbox. So please ask us as many questions as you need. Like Mark said, we can offer some GDPR services such as consulting and gap analysis. So please reach out to us if you have any questions. Sorry for our technological issues today. Thank you for sticking with us throughout the beeps. This recording will be in your inbox tomorrow along with a copy of the slides. So hopefully that'll be helpful to you as you figure out how GDPR applies to you. Mark, thank you so much. That was so helpful. And everyone have a great rest of your day.